Welcome to the deep dive. Today we're tackling something absolutely vital for understanding mental health care.
Mm.
The legal and ethical principles that psychiatric mental health nurses deal with, well, every single day. Think of this as your shortcut to getting a handle on these complex spots where, you know, individual rights meet community well-being.
And you've brought a really valuable resource here, Vaccarolus' Essentials of Psychiatric Mental Health Nursing. Our goal today is really to unpack the core information in there.
Yeah, give you a clearer sense of that delicate balancing act involved.
That's it, exactly.
Because psychiatric care, at its heart, is always trying to find that balance, isn't it?
Mm.
We're talking about protecting the patient's fundamental rights while also, keeping society's safety and rights in mind. It's a central tension.
A really key tension. We'll definitely explore that.
Yeah.
And this field, it doesn't stand still. The laws around mental health, they've changed quite a bit, especially since, say, the mid-20th century.
Real-
A huge moment was the Community Mental Health Center Act of 1963. That really kicked off the shift away from long-term institutions towards community-based care.
A shift that was helped along, I think, by better medications, too, right? Allowing people to actually live in the community.
Absolutely. Effective psychotropics made a huge difference. And alongside that, there's been this growing recognition societally of treating patients with respect, respecting their autonomy.
Mm-hmm.
And more recently, you have major laws like the Mental Health Parity and Addiction Equity Act, MHPAEA, from 2010. And that continued through the Affordable Care Act.
Which had a massive impact.
Huge. It opened up access to mental health and substance abuse benefits for millions, making sure they were on par with medical benefits, even included preventative mental health services.
So, okay, with that background, our deep dive today is aiming for something pretty clear. We're going to give you a solid grasp of these essential legal and ethical principles.
Yeah.
We'll focus on key things like patient rights, the absolute necessity of confidentiality, and of course, patient safety.
Sounds good. So where should we start? Maybe how people actually get into and out of psychiatric care.
Perfect. Admission and discharge. Because the procedures there are governed by really strict legal ideas. And one of the biggest is due process and civil commitment.
Right. The Supreme Court, way back in 72, Humphrey v. Cady, they called civil commitment a massive curtailment of liberty.
Wow.
Yeah, it really underscores why you need fair, just procedures. You can't just lock someone up without due process.
And that brings in things like the writ of habeas corpus.
Exactly. That's that legal tool, the great writ, letting someone challenge their confinement if they think it's unlawful. And then there's the least restrictive alternative doctrine.
Which just sounds like common sense, really.
It kind of is. Basically, you have to use the least drastic approach that still works. If outpatient treatment is safe and effective, you shouldn't force inpatient care. That would be unnecessarily restrictive.
Okay. So how does someone actually get admitted? What's the difference between voluntary and involuntary?
Voluntary is, well, pretty straightforward. The patient themselves, or maybe their legal guardian, applies in writing.
They choose to be there.
Right. And, importantly, they generally have the right to ask to leave any time. Now, there's a little caveat.
Oh.
Many states allow for a temporary hold. If the person asks to leave, but the team thinks they might be in immediate danger, they can hold them for a short period for assessment before just letting them walk out.
Okay, that makes sense. Safety first.
Mm-hmm.
And involuntary, that's without consent.
Correct. Involuntary admission happens without the patient agreeing to it. It's typically for very specific situations. Usually the person needs treatment and is considered a danger to themselves or others, or maybe they're so ill they can't meet their basic survival needs.
And how does that involuntary commitment happen? Is it just one way?
No, there are a few common routes. You might have a judicial determination, a formal court hearing where a judge decides, or administrative determination, maybe a mental health board or a specific professional makes the call based on legal criteria. Sometimes a state agency can start the process in emergencies. And the commitments themselves vary too, like emergency holds for immediate crises, observational stays for assessment, longer-term commitments, and then there's involuntary outpatient commitment.
That outpatient one sounds interesting. Involuntary, but outpatient.
Yeah, it's a newer approach. Often it ties things like disability benefits or housing aid to the condition that the person keeps up with their treatment plan.
That definitely sounds like it raises some ethical questions. Autonomy versus making sure someone gets help.
Exactly. It's that constant tension. Paternalism versus autonomy. How do we ensure people get needed care without trampling on their right to self-determination?
Tricky balance.
Yeah.
And discharge. How does that work for both types?
Well, for voluntary patients, like we said, they can request release. There might be that temporary hold or maybe a conditional release where they agree to follow up outpatient treatment. Safety net, basically.
Yeah.
For involuntary patients, discharge usually needs a formal court order or an administrative one. It signifies that the legal reasons for keeping them there don't apply anymore.
Okay, so once someone's in the system, voluntarily or not, what rights do they have?
A really fundamental one is the right to treatment. There's a federal law from 1964, the Hospitalization of the Mentally Ill Act, that requires public hospitals to provide medical and psychiatric care.
So they can't just be warehoused.
Exactly. And while the Supreme Court hasn't said there's a constitutional right to treatment everywhere, courts have laid out criteria for what adequate treatment looks like. Things like a humane environment, enough qualified staff, an individualized care plan.
Makes sense.
And that O'Connor v. Donaldson case in '75 was huge. It said you can't just confine someone indefinitely if they aren't dangerous and can survive safely in the community.
Right. And what about refusing treatment? That seems like a big one, too.
Absolutely. It goes hand in hand with informed consent. Patients generally have the right to say no to a specific treatment or even withdraw consent they previously gave.
Even for medications, I know that comes up a lot, the idea of chemical restraint.
It's a very complex debate, especially with psychotropic meds. There's been a lot of legal evolution there. Cases like Rogers v. Aachen in Massachusetts really dug into this. It's always trying to balance the state's interest in providing care against the person's right to decide what happens to their own body.
So generally, if someone is competent and not involuntarily committed.
They generally have the right to refuse.
Okay. Which brings us straight to informed consent.
The bedrock, really, rooted in self-determination.
Right.
That Canterbury v. Spence case really nailed it. Providers have a duty to disclose the risks, benefits, alternatives, everything, so the patient can make a real choice.
And what needs to be disclosed for consent to be truly informed?
Well, the basics are the nature of their condition, what treatment is being proposed, the likely benefits, but also the significant risks. What are the alternatives? What's the probability of success? And what are the risks if they don't consent?
That's quite a list.
It is. And critically, just because someone has psychotic symptoms doesn't automatically mean they're legally incompetent to make these decisions.
Right. Competency is a legal determination, isn't it? Not just a clinical judgment.
Exactly. It's decided by a court through a specific process. If someone is found legally incompetent, then the court might appoint a guardian to make healthcare decisions for them.
And that's different from a power of attorney.
Yes. A POA usually can't override the person's wishes if they're still considered capable. And there's been growing concern about guardianship potentially being misused, so some places are putting in more safeguards.
Okay. What about everyday nursing stuff? Does taking medication imply consent?
For many routine things, like accepting a pill offered to you, yes, we often work under implied consent. But for anything more intrusive or with higher risks, you need that explicit, often written, informed consent.
And what about planning ahead? Can patients state their wishes beforehand?
Yes, that's where psychiatric advance directives come in. They're becoming more important. It's a way for patients to document their treatment preferences before they might become unable to make those decisions later on.
That sounds really valuable.
Yeah.
Okay, another critical area.
Mhm.
Restraints and seclusion. What are the rules there?
The absolute guiding principle is least restrictive means. Shortest duration possible. Always.
Meaning you try talking first.
Always. Verbal interventions, de-escalation techniques, those are the first line. Restraint or seclusion should be a last resort when there's imminent danger.
And the rules around using them have gotten stricter, I imagine.
Much stricter over time. Agencies like CMS Centers for Medicare and Medicaid Services and the Joint Commission have very detailed regulations. Things like time limits based on age.
Oh, interesting.
Yeah, shorter limits for children and adolescents.
Yeah.
You need a written order from a doctor or qualified practitioner, usually obtained within an hour if it's an emergency start. Constant safety monitoring is crucial. Regular assessments, documentation every 15-30 minutes typically.
Wow, very tight controls.
As they should be. And importantly, there are contraindications. You wouldn't use restraint or seclusion if someone has certain unstable medical conditions, delirium, or sometimes even severe suicidal tendencies where it might actually increase risk.
Okay, let's shift gears to something incredibly sensitive.
Yeah.
Confidentiality.
Paramount in psychiatric care. Absolutely crucial. It's grounded in the right to privacy, the ANA Code of Ethics.
And HIPAA wrote.
HIPAA provides the main legal framework. Generally, you can't disclose patient information without their consent, except for specific things like treatment, payment, or healthcare operations.
And psych records are sometimes treated even more strictly.
Often, yes. They frequently require a separate, specific authorization for release beyond general medical consent. And simple things like talking about a patient in the hallway or cafeteria can be serious breaches. You have to be so careful.
Does that confidentiality end when a patient passes away?
No, actually. The right to privacy continues after death. You still need proper legal authority to access a deceased patient's records.
Okay. And what about privilege? Is that different from confidentiality?
It's related but distinct. Patient privilege, like nurse-patient privilege, is a legal concept. It means communications within that therapeutic relationship are generally protected from being disclosed in court proceedings without the patient's consent. The idea is to encourage people to talk openly without fear it'll be used against them.
But it's not absolute. There are exceptions.
Correct. There are legally required exceptions, things like reporting suspected abused child or elder abuse or certain criminal activity. These specifics can vary quite a bit state by state, though.
So nurses need to know their local laws.
Definitely. And a major exception we need to talk about is the duty to warn and protect third parties.
Ah, the Tarasoff case.
Exactly. Tarasoff v. Regents of University of California. A landmark pair of cases, really.
What was the upshot? It created a tension, right?
Yeah.
Between confidentiality and safety.
A huge tension. The court ultimately ruled that therapists have a legal duty to take reasonable steps to protect an identifiable potential victim if a patient makes a credible, serious threat of harm against them.
And reasonable steps could mean warning the victim or the police.
Yes, potentially both. Warning the intended victim, notifying law enforcement. The second Tarasoff ruling broadened it slightly from just a duty to warn to a more general duty to protect.
Does that apply just to therapists or nurses too?
Well, it originated with therapists, but the trend in many states suggests it could extend to advanced practice psychiatric nurses and maybe even staff nurses if they know about a serious threat and don't report it within the team. Many states now have some version of this duty, though the details differ.
Okay. You mentioned reporting abuse earlier. Child and elder abuse.
Yes, critical legal duties there. All states have mandatory child abuse reporting laws. A growing number have similar laws for elder abuse or vulnerable adults.
And healthcare professionals are almost always mandated reporters.
Almost always. The laws define what counts as abuse or neglect, who has to report it, and which agency receives the report. Nurses absolutely must know their state's specific requirements.
Are there conflicts sometimes, like with federal confidentiality laws for substance abuse treatment?
There can be complexities, yeah. Especially with 42 CFR Part 2, the substance abuse confidentiality rules. But federal law does have exceptions allowing child abuse reporting in certain situations, like with a court order or if you can report without identifying the person as being in substance abuse treatment.
Okay. Let's touch on tort law. How does that apply here?
So a tort is basically a civil wrong that causes harm, leading to potential legal liability, usually money damages. In healthcare, you see intentional torts.
Like assault, battery.
Exactly. Battery is unwanted touching without consent. Assault is creating the fear of immediate harmful contact. And false imprisonment, unlawfully restricting someone's freedom of movement. There was that case, Clumador v. State of New York, a really stark example of false imprisonment and negligence in a psych setting.
And negligence itself, or malpractice, is probably the most common basis for lawsuits.
Very common. To prove negligence, you generally need 4 things. Duty, the nurse had a professional duty of care. Breach, they didn't meet the standard of care. Causation, that breach directly caused the injury. And damages, actual harm, resulted.
What defines that standard of care?
It's what a reasonably careful nurse with similar training and experience would do in the same situation. We look at professional standards, like from the ANA, hospital policies, even common practices.
And what are common problem areas in psych nursing liability?
Patient safety issues are big: suicide prevention, preventing elopement or violence. Miscommunication within the team is another. Medication errors, unfortunately. Boundary violations, abusing the therapeutic relationship, and sometimes misdiagnosis or flawed treatment planning.
So given all that, what should a nurse do if they suspect a colleague is being negligent? That seems like a tough spot.
It is tough, but there's a professional and often legal duty to report risks to patient safety. The first step is usually careful documentation. What did you observe specifically?
Okay.
Then, if it feels appropriate and safe, maybe talk directly to the colleague. But if the behavior continues or if it's a serious immediate risk, you absolutely have to go up the chain of command, supervisor, manager.
And if that doesn't work?
Then reporting to external bodies like the State Board of Nursing might be necessary. The ANA Code of Ethics is really clear. Nurses have a duty to act on incompetent, unethical, or impaired practice.
And that duty extends to intervening directly if you see something wrong happening, like a bad order.
Yes, you have a duty to intervene if patient safety is at risk. That might mean questioning an order you believe is incorrect or harmful and escalating it if your concerns aren't addressed. It's about patient advocacy, not just blindly following orders or interfering inappropriately.
Is patient abandonment also considered negligence?
It can be, yes. If a nurse just stops providing care without making sure another qualified person is taking over properly, that could be abandonment.
What about reporting other unethical things, like drug diversion or sexual misconduct?
Also, a fundamental responsibility. It can be incredibly difficult, worrying about reputations and fallout, but many states legally require it. And ethically, patient protection has to come first.
Okay, one last really crucial piece seems to be documentation.
Absolutely critical. Cannot emphasize it enough. The medical record is everything.
Why is it so vital?
So many reasons. It's how the team communicates, ensures care continuity shift to shift. It's used for risk management, quality improvement, billing, and utilization review. And crucially, it's legal evidence. If anything ever goes to court, the record is central.
And documenting threats is particularly important.
Very important for both legal and safety reasons. Documenting threats of harm to self or others is essential. And with electronic records now the norm, things like password security, authorized access, making corrections properly, all vital.
There's also that new law, the 21st Century Cures Act, about patient access.
Right. That's mandating patients get easier access to their electronic health records. That includes things like mental health notes from primary care visits, though usually not detailed psychotherapy notes. It's definitely going to raise new legal and ethical questions as we go forward.
Wow. We have covered a huge amount of really critical ground today.
We really have.
And bringing it all together, it really does feel like that central theme holds true. Constantly balancing individual patient rights with the safety and well-being of the community.
That's the tightrope, yeah.
Right.
And navigating it isn't something you just learn once. It takes ongoing learning, staying current, really engaging with things like the ANA Code of Ethics and standards of practice.
So understanding rights, keeping confidentiality, prioritizing safety, those are the non-negotiables.
Absolutely. Fundamental responsibilities for every single psychiatric nurse.
So as you, our listener, reflect on this deep dive, maybe think about how these laws and ethics are always evolving. Society changes, technology changes, our understanding of mental health changes. How might these principles keep adapting in the future? How do we best serve both the individual facing challenges and the community they live in?
That's a great question to ponder. How do your own values intersect with these complex frameworks? It's something for all of us in this field to keep thinking about.